Ladies, you can begin.
Hi, good evening, everyone. Good evening, good evening. The National Coalition of 100 Black Women, Pennsylvania chapter is pleased to present SisterNomics, Estate Planning, Building a Legacy, Part 1. My name is Michelle Smith. I'm a member of the Economic Empowerment Committee. We are delighted to have two dynamic speakers who will share their expertise on how effective estate planning can help protect you, your family, your home, and your assets. We do have a poll in front of you, so if you have a few moments, if you can answer the poll, and then we will continue on with the presentation. And thank you for completing the poll. As you come in, please feel free to complete the poll as you enter the webinar. Okay. We will begin our program with welcome remarks from our first Vice President, Naisha Chapman, followed by our first presentation by Ms. Monica Kitt, Esquire, then a Q&A session. Next, and then afterwards, we will have another presentation by Ms. Carol Robinson, followed by another Q&A session. And then we will have a personal testimonial by our very own Sister Sho Gaston, Esquire. Now we will have welcome remarks by our first Vice President, Naisha Chapman.
Thank you, and good evening, everyone. As stated, I am Naisha Chapman. I'm the first Vice President of the National Coalition of 100 Black Women, Pennsylvania chapter. On behalf of our President, Latifah K. Fields, I welcome you to our SisterNomics Estate Planning, Building Your Legacy virtual seminar. The mission of the National Coalition of 100 Black Women is to advocate on behalf of Black women and girls to promote leadership development and gender equity in the areas of health, economic empowerment, and education. Across the United States, we are comprised of 2,800 members in over 62 chapters. Through our national and local partnerships, we are proud to be a voice for our community. For more information about the National Coalition of 100 Black Women, please visit us on our website, www.nc100bw-pa.org. The Pennsylvania chapter is one of the largest chapters within our organization with over 160 members, where our work focuses in the Philadelphia region primarily. As one of the organization's advocacy priorities, our SisterNomics program and initiative focuses on creating a path to financial wellness through self-sufficiency. The goal of our SisterNomics programming is to educate Black women and girls on financial literacy, family wealth building, and increasing Black entrepreneurship. Thank you to our subject matter experts, Ms. Monica Kitt, Esquire, and Ms. Carol A. Robinson, and to all of you joining in today. We truly hope that you leave with additional knowledge on how to build your legacy through financial planning. Remember that tomorrow is not promised, and it is important that you get your financial house in order today. I will now turn it over to our Economic Empowerment Committee, and thank you again for joining.
Good evening. My name is Cassandra Luberis, a member of our Economic Empowerment Committee. I have the privilege of introducing our very first speaker of the evening. Attorney Monica Kitt is a native of the Philadelphia area and a graduate of Temple University Beasley School of Law. She owns the law offices of Monica R. Kitt, LLC, where her philosophy is a personalized, practical approach to estate planning, which focuses on educating clients and customizing plans to meet the needs of each client's present and future goals. Helping clients to understand the legal impact and benefit of estate planning while also striving to make estate planning attainable at any income level is her first priority. As an attorney, she has many years of experience executing and evaluating legal documents, including powers of attorney, healthcare directives, i.e., living wills, and various types of contracts. She has the experience in both litigation and transactional areas of law, such as personal injury, medical malpractice, cybersecurity compliance, settlement negotiations, and various types of hearings. She's a trained litigator, published author, experienced arbitration panelist, and a member of the Philadelphia Bar Association. Ms. Kitt is a member of Enon Tabernacle Baptist Church. Her hobbies start with and go on from racquetball, golf, through theatrical arts, music, and so much more. Today, Attorney Kitt is eager to educate you on the estate planning process and hopefully serving to assist you with your future planning needs. Thank you.
Thank you so much. I want to first give recognition to Gwen Williams, a longtime friend of mine who actually introduced me to the coalition, and I am thankful for this opportunity to educate you in the estate planning process. So now let me attempt to engage the right buttons here so that we can get started. So let me screen share with you. Tell me when you see my screen. Say test slide.
Yeah, we're good to go.
Okay. All right. Let's begin. A question for you. Are you prepared for the future? Before you answer that question, let me give you a little hypothetical. I want you to imagine that you're driving down 76 heading towards Center City, and you round the curb at the 30th Street exit ramp. As you round the curb, you see there's traffic under the overpass, and you get in line in that traffic because you can't get off on the ramp because you're headed towards the airport for vacation. While you're sitting there in traffic and it's inching along, it's a rainy day, you notice that behind you is a box truck approaching you, and you note to yourself that truck's moving pretty fast. Truck continues and it doesn't seem to be slowing down. You notice the truck starts to swerve a little bit on the rain. And as your heart sinks, the truck does hit you in the rear end of your car. The impact from the truck pushes you into the car in front of you, and the car in front of it also hits the car in front of it. So you've got at least a 3-car pileup. You notice all of a sudden you have pain in your legs, you have pain in your rib cage area. People start to get out of their cars to try to assist, and at that juncture, you pass out. You awaken and you find yourself at the University of Pennsylvania Hospital. You hear people talking around you, but you're not even oriented yet. And you're hearing them say, well, we just came out of surgery, and due to her injuries, we had to amputate Miss Jones' right leg. We noted that she's having some difficulty breathing. Have we found any documentation as to emergency contacts or even, any type of healthcare directive in the glove box of her car or her pocketbook? And they say no. You also overhear in the hallway that another person in cars in front of you that was involved with that accident. You hear them talking about the fact that they contacted Mr. Anderson's wife. They did find a healthcare directive in his glove compartment of his car, and his wife is on her way, and she will help them make medical decisions for him. That juncture, you hear the nurse say that your oxygen levels are below normal. They're at 70%, and you notice you're having trouble breathing, even with the oxygen mask on your face. And you hear the doctor say, well, we don't know who to contact. We didn't find any emergency contact information, and we're going to have to make some critical decisions in Miss Anderson's case, Miss Jones's case. So they say we're going to have to put her on life support because she's still bleeding internally, right? So I ask you again, are you prepared for the future? And I say estate planning can be the answer. You ask, what is estate planning? You may have heard of the term. You ask, where do you begin? I'm going to answer that today. Estate planning is a process of arranging how and who will manage your affairs if you become incapacitated, and or who will manage your assets if you should pass away. Estate planning ensures that you and your assets are managed by persons that you trust if you become incapacitated. And when I say incapacitated, I'm referring to if you can't make legal decisions for yourself due to either physical or psychiatric impairment. Estate planning ensures that your assets go to who you intend after your death if you pass away, not persons defined by the courts. It minimizes the impact of taxes on your assets so that your surviving beneficiaries keep more of your wealth, and that's the intent. How do you get started, you may ask? You identify first your assets, and I'm talking about real estate, any houses, any rental properties you may own, any business properties that you own. That is part of your assets. Also personal property. That could be bank account, CDs, IRAs, your personal effects, clothing, furniture, your car, SUV, all those things, the tangible assets are part of your assets. And your potential future needs. And you need to think about 5-10 years from now. What are your goals? Your financial goals, your family planning needs? Do you have children or grandchildren that you need to care for, or parents that you need to look out for? Health management. Think about if your health starts to deteriorate, what would you do? Who would you want to speak for you? You locate relevant documents such as property deeds, financial statements, birth and marriage certificates, divorce decrees, separation agreements, if that's the case, and determine persons who you trust to manage your care and or your assets, who are responsible and good with handling business. Also, you want to identify potential beneficiaries of those assets. Who do you want to leave things to? Who do you think would be the best beneficiary to take care of the legacy that you have built? And guardians for loved ones. Do you have young children that you need to leave instructions for, and who you want to care for those persons, or parents, or special needs children who are adults, but because of either autism or psychiatric illness, they need assistance? Seek both legal and financial planning assistance from estate planners and financial professionals, namely an estate planning attorney like myself or a financial planner like Carol. A lot of people think about using those online templates, but I would warn you about some of those online templates. They're not going to customize your plans for you. You may have special family circumstances or certain conditions that you want to build into it. In addition, Carol and I, we think of what can happen experiences that you may not be thinking about as a layperson. And we will be using our experience with other clients and things that we have seen to give you good advice on protecting your assets, protecting your own personal well-being. Estate planning documents, what are they? Let's talk about them now. Estate planning packages are comprised pretty much of the documents here: testamentary will, we're going to talk about each one and their attributes; financial power of attorney; healthcare directive, that's a combination of a living will, Probably heard that term in a healthcare proxy or healthcare power of attorney. Guardianship designation, revocable trust, and irrevocable trust. Let's look at each one of these documents. A testamentary will identifies who controls and receives your assets after your death. It defines who is the guardian for minor children, if that's the case, or incapacitated relatives that you may be responsible for. Some of the benefits of the testamentary will is you decide who handles your estate. And as I said, your estate is comprised of your real estate holdings and any personal assets, personal property, and who receives those assets. And you know in your mind who is the best person to manage certain assets that you have. Not the state court based on intestacy statutes. If you don't have a will, then the state court will decide who gets your property. Okay, and they have certain formulas that they distribute without concern of that person's personality or their ability or who would be the best person to handle that asset. So the disadvantages of a testamentary will is public notice is still required subject to the probate court process, meaning they will have to announce that your estate is being open and publicly announce the assets that are part of your estate. Financial power of attorney. Financial power of attorney defines who and when your designated agents has control over your assets. Again, you can decide and we can build conditions as to when that power of attorney becomes effective. It identifies what powers are you giving that designated person or agent over your assets? Do they have the ability to sell real estate for you? Do they have the ability to operate a business for you? Will you give them charge over your bank accounts or your artwork or buying and selling your assets if you become incapacitated and can't speak for yourself? So the benefits of the power of attorney, of financial power of attorney, is you dictate when and who handles those assets. You will decide who is your agent and not the state court unless an emergency petition has to be executed. Powers of your agent can be customized even during your legal incapacity, again, when you're no longer able to speak for yourself. That's what we call a durable power of attorney. I'm going to mention below. Some of the disadvantages, state court oversight typically is not provided over an agent unless that agent abuses their powers. They go beyond the written powers that you've given them, or they misallocate funds and use them for their own benefit against your will. Litigation suits can be held against those persons. Powers of an agent end upon your incapacity unless you have a power of attorney that's a durable power of attorney. And that's where it said you would build conditions that say this power of attorney will continue even after my incapacity. Otherwise, that power of attorney will be nullified if you lose your capacity. Okay, and your death ends all power of attorneys. A power of attorney doesn't have default provisions to become your executor if you pass away. That is the will that you have to design will speak to who that executor is. Sometimes people think the power of attorney still has the right to stand after a person dies, but those rights end upon a person's death. Healthcare directive. It's a living will as well as a healthcare power of attorney. Living will defines what care and treatment you would want if you are terminally ill and legally incapacitated. The scenario I gave earlier, the healthcare directive would speak to whether you want life support or extraordinary measures in certain circumstances. You can decide when and how and what kind of care that is through a healthcare directive. Healthcare power of attorney identifies who makes that healthcare decision for you. Is it a child? Is it a spouse? Is it a friend during your legal incapacity? You want to avoid making doctors your healthcare power of attorney because there's a conflict of interest in that situation. But you do want to notify your doctor once you build a healthcare directive. Benefits of it, it honors your healthcare decisions during your legal capacity. Again, when you can't speak for yourself, what kind of care would you want? Even what hospital would you want to be treated in? You can drill it down to that type of specificity. Court intervention over your healthcare is typically not required, again, unless there's an abuse by that power of attorney. And powers of your agent can be customized during your capacity. You designate how much information and what powers they have over making healthcare decisions for you. You can have more than one agent. You can have alternate agents also. If one can't serve, the alternate can step in their place. Disadvantages: state court oversight isn't typically provided for that agent, and that power of the healthcare agents ends upon your death, similar to the financial power of attorney. Guardianship designation. A court appoints a legal guardian to take care of persons who cannot care for themselves and or their property due to either age, meaning a child, let's say they're a minor, or mental illness, let's say an elderly parent has dementia, or you develop dementia, or a type of condition that impairs your ability to make decisions for yourself, or there's physical disability, wheelchair bound and you need assistance. Court certifies the powers of that appointed legal guardian. Some of the pros of that and benefits are typically they're used for children who are minors and persons who are adults, but who are legally incapacitated and cannot take care of themselves. I'll give you an example. I had a client I set up a guardianship for, and her son had autism. He was 33 years old, and he was involved with doctors who were taking him, having him sign documentation regarding his health, and he basically had the legal capacity of a 6-year-old child. So his mother had to step in and get a guardianship appointed for him because of his autism. Some disadvantages of the guardianship: it requires due process notice, meaning anyone who has a relationship, either business relationship or if they're receiving benefits from the state, or their familial relationships, other relatives, we have to give them notice that a guardianship petition is going forward, and they have a right to be a part of that court hearing, either to confirm the appointment of the potential guardian or to challenge that particular guardianship petition. It is a court hearing before a judge who reviews layperson and medical expert testimony. A medical expert has to certify that the person lacks the capacity and requires a guardianship. The alleged incapacitated person, the AIP, as we refer to them before the guardianship is finally executed, must also attend the hearing unless special circumstances apply. And that can be a situation where someone's bedridden. And it may take several weeks to complete a guardianship. I will say now, if you have a financial power of attorney and a healthcare directive, if you were the person that needed a guardianship, those two documents could be a substitute from needing this court proceeding. Trust. There are various types of trusts based on different situations, but a trust in essence allows centralization of your asset management during your life, where you can be the trustee, or in capacity. If you become disabled, the trust can be engaged, or after death. There are trusts that you can build that take effect after your death. They can be conditionally designed to protect assets and or vulnerable beneficiaries. Let's say you have a teenager and you want to build a trust and they're not good with money. You can build a spendthrift trust for that particular teenager so that the trustee, whether it's you or someone else, can be ordered to pay out a stipend, a certain amount of money to that beneficiary per month. You can customize the trust. There are two types: revocable trusts, and the large categories are those that can be amended and controlled by you during your lifetime, if you so please, or irrevocable trusts. Usually are not amendable and are typically used after your death. Benefits of the trust is it avoids the probate court process altogether, because the items in the trust, the property that's in the trust, will be titled to the trust, and it's no longer an asset that has to go through the probate public announcements, etc., and related public disclosures, okay, that we talked about under the will, where we have to announce the estate and declare all the property that's in it in case creditors want to come forward to redeem debts. Okay, it's customized, designed, is possible for many different situations. There's something called a Q-tip trust. Spouses usually build those for their surviving spouse to hold property for that spouse for their life, and then maybe pass it on to children or stepchildren if this is a mixed marriage. Joint trust. We have charitable trusts. There's special needs trusts for disabled persons. There's insurance trusts, spendthrift trusts, there's credit shelter trusts, asset protection trusts. Blind trust, where beneficiaries don't know who the assets are going to go to until it's time for the release. In A/B trust. So there are many different kinds of trust that can be customized based on your needs. It requires, and on the negative side, retitling assets in the name of the trust. It needs proper management by a trustee, which can be a professional trustee or a person, friend, or yourself. And funding. The trust must be funded to be effective, meaning you've got to retitle those assets in the name of the trust, and the trust, in essence, becomes like the owner of those assets, at least on paper anyway. And it can be expensive to create and manage. If you have a professional trustee, they may ask a salary because of all the costs and things to manage those items. Property has to be upkept. Taxes need to be paid. Utilities may need to be paid for certain property. But there are tax savings and asset protection. It varies depending on the type of trust. Next item, estate planning, the process. First, you would hire an estate planning attorney who you're comfortable working with. You can interview that attorney just to get to know them. The next step would be the interview process, that the attorney would be interviewing you as a client, and a questionnaire. Particularly in my office, I have a questionnaire that I give to my clients to complete, because that will list all of your assets and also what your estate planning goals and needs are. And that's where I would begin my analysis of looking at what's the best vehicle to accomplish your goals. Review and sign a representation agreement. That representation agreement is between you and the attorney, and it speaks to what your responsibilities are as a client to the attorney and what the responsibilities of that attorney are to you, including confidentiality. Okay. The next step would be, once we've examined the questionnaire, had the interview, initial drafts, and review of those drafts. We create the documents you're asking for, whether it's a will, whether it's power of attorney, healthcare directive, trust, guardianships, and then I would sit down with you and review the different particulars of that particular document to make sure you understand it, and then so that you can translate it to the agents that you're appointing and executors, depending on what kind of document it is. You complete the documents with a notary and witnesses, and what this does is help to solidify that that document is a valid document and you have the legal understanding and capacity to sign that document. And that way it's harder for anybody to challenge that document after you pass, or challenge that document if you become incapacitated, all right, in terms of its validity. A basic package can run from $300 for a single item, a single document, all the way up to $1,200 for, say, a will, healthcare directive, and financial power of attorney. Trusts are more expensive because they're much more complicated documents and have a lot of provisions that have to be built into it. And once again, this is just round numbers because it depends on the complexity of the documents based on conditions that you have. But that's on average cost for, like I said, a will and power of attorney and financial power of attorney package. Discuss with your representatives and what those documents are and their role in it, and then provide copies or store those original documents for future use. Safe in your home, not a safe deposit box, because if something happens to you, they won't be able to access that deposit box unless special conditions are determined. But that's something that the attorney or myself would counsel you about, how to secure those documents for future use. Future amendments for situational changes. These documents are not static. They can be changed based on your changes. Let's say assets change. There's a birth or death of a loved one that requires a change of those documents, or your goals change. All right, now let's take a look at probate process. All right, the estate planning aspect happens before you pass away, and most of those documents are effectuated during your lifetime, except for the will. Once you pass away, the estate administration process takes over. This is not an area that my office specializes in, but I do have access to persons if you need this type of assistance. Today we're going to talk about how long, and how much. All right, on average, it takes about 6 to 2 years, possibly depending on the size of your estate, to identify assets, debts, and proper notification requirements that the law has established. If you have a will, The property distribution is set by testator, that would be you, your instructions in the will. If you don't have a will in the probate process, then the court will decide how your property is distributed. There are court fees and executor expenses and professional services sometimes if you need an attorney, if you need an accountant, if you need persons to do assessments. And we're going to talk about that in a moment. It can be thousands of dollars. And I'll say just in Philadelphia alone, and each county has its own list of fees. It's based on typically the size of your estate. There are certain fees, certain filing fees for documentation. Tax rates are based on relationship to the decedent or testator if there's a will. Spouses are taxed at 0% in terms of, we're talking inheritance tax. Children at a 4% rate. Parents, if property is going to parents, 12%, and all others at 14%. And these are based on Pennsylvania law. So those of you who live in different counties, it's a similar process, even if you live outside of Philadelphia. Probate process itself, you have to obtain the death certificate and petition the register of wills to begin the probate of the estate. Again, the estate is everything that you own, okay? Or a person, if you're acting as executor for someone, everything they own. Legal and local publication of letters of testamentary. If you have a will, we'll issue letters based on, we're announcing the estate is going to be open, the will does exist. We've got to publicly notify everybody of the assets in that estate. If there is no assets, they call the letters, the notification letters, letters of administration. Notice letters are to the Department of Public Welfare for estate recovery claims. Let's say you have benefits of some sort, Social Security, or you had nursing home care. We'll have to provide notice so that those creditors, if need be, and those agencies know that you are no longer alive and those benefits have to stop, or creditors, like in the case of nursing home fees, will know that now they have to work with the executor to recover any outstanding costs, last expenses, for example, hospital costs. Certification of and notice of those beneficiaries under PAOC Rule 5.7 and 5.6, that merely speaks to the 3-month requirement for administration of that estate. You have to provide those letters at least for public notice, all right? Collection and valuation of assets. This is where you might have to need the services of an appraiser, which would be another cost to evaluate assets a person has. You would have to set up the estate with its own EIN, and that's a almost like a business, an employee identification number, because it is the estate, and you as an executor, if you're acting for someone else, will be managing that estate under an EIN number for tax filing purposes and documentation. The estate cash requirements. You've got to estimate what kind of cash do I need to fill out forms and file forms with the register of wills. I'm going to be talking to a specialist in that area in a week or so. Raise necessary cash if need be. Payment of any debts that have to be taken care of. These are all considerations. Consider payment of the inheritance tax at a discount. If you pay that tax within 3 months of the death of the person, there is a 5% discount for paying early, but you have 9 months to file that tax return for the inheritance tax. Consider sale of real estate holdings or complete transfer to title. Those are things you have to keep in mind if you're administering someone else's estate, or if someone's administering yours, they have to think about those things. Whereas if you build your estate planning document, you will save them a lot of work because you've already allocated what your assets are and different instructions for that. Step 9, preparation of and filing of the estate inventory may occur. You've got to inventory everything that person owned, okay? That may incur more probate fees depending on the size of that estate. Preparation and filing of a PA inheritance tax return. Payment of that tax will be due, as I said. 3 months is the ideal because you'll get a discount. Beyond that, 9 months filing. Preparation and filing of the final life period personal income tax. Their final tax for that person who passed away, and for any income and assets that were managed by them for whatever period of time they lived in that calendar year. You still have to file a final tax return for them. Tax planning and consideration of making an advance distribution to beneficiaries. After steps above have been completed, start thinking about distribution into those beneficiaries. If you have a will, that'll make it much easier on that executor or that personal representative acting. Preparation of the final accounting, submit that proposed schedule of distribution and receipts to the register of wills. And then last step is distribution of those assets to beneficiaries only after that inheritance tax has been appraisal has been completed and issued, and after those heirs have submitted their fully executed receipt and release of indemnification. Now, I know step 14 can be a little bit of a challenge because sometimes family members may challenge who is the executor. They may contest for different reasons, but there is the opportunity, if you need to ask for assistance from the Register of Wills for them to come before a administrator and show cause. I have been involved with the case years ago where that was an issue. I was working with another attorney who does probate work. So at this juncture, I know that's a lot of information. I will open the floor to any questions on estate planning. And once again, that's the front end of things for me.
Okay, good evening. We do have one question. The question is, just to clarify,
Yes.
if you have a financial POA and or healthcare POA, the process of guardianship becomes unnecessary for the POA.
Okay, like I said, remember the healthcare directive, and depending on how you design your financial power of attorney, if you have a durable power of attorney, remember that becomes effective if you're incapacitated. So think of it like this. A guardianship is if you don't have those documents, then a guardianship petition will be required. You'd have to go to, let's say you developed dementia and you couldn't act on your own behalf. Then someone would have to petition the court to become your guardian. If you have a financial power of attorney, it's a durable that says, my daughter is my power of attorney, and this power of attorney, financial, to handle my financial affairs, will continue even upon my incapacity. Then you don't need the guardianship. Same thing with the healthcare directive, because a guardian can be a person responsible for your financial management as well as healthcare and your person, we call it in the law, the care of the person, making healthcare decisions for you, buying clothes, doing all kinds of things that you can't do for yourself. If you have that healthcare directive in place, and let's say you become incapacitated, you're unconscious, and they don't know what to do with your healthcare, they would refer to that healthcare directive. And then the guardianship, again, wouldn't be required for that area of your life. Do you understand? Hope I've addressed that question.
Are there any more questions? Okay. That is the only question that we have for you tonight. We're going to move on to our next presentation.
Okay. And I just have my contact information on screen. If you have questions or want to reach out to my office, you can either come through the website or directly email me at the email address on the screen. And I want to let you know that I'm starting a email subscriber program. So go to my website and you can sign up, and I'll be sending out tips and different pointers and resource documents about estate planning. So thank you for your time.
All right. Thank you, Ms. Kitt. Good evening, everyone. My name is Erica Graham. I have the pleasure to introduce Ms. Carol A. Robinson. Ms. Robinson is a native Philadelphian. She is a tax and retirement planning professional and the president, CEO of Fast Tax Financial Services Company, which renders tax, accounting, insurance, and financial services to individuals of small businesses in Delaware Valley, Maryland, Washington, D.C., Virginia, and North Carolina. She has offices located in Bala Cynwyd, Pennsylvania, and Owings Mills, Maryland. Carol inherited her spirit of entrepreneurship from her grandparents, who owned real estate and several other businesses in North Philadelphia. Carol earned an accounting degree from Temple University and an MBA in marketing from Philadelphia University. She holds a Pennsylvania, Maryland, Washington, D.C., Virginia, and North Carolina insurance license in life, health, and annuities. Carol started and ended her corporate career at Sun Company as a tax accountant and a financial systems manager. She also worked for ARCO and Atlantic Refining and Marketing Corporation as a financial accounting manager. In 1991, Carol decided to explore her entrepreneurial talents and on a full-time basis after taking an early retirement package from Sun Company. Carol started Fast Tax Income Tax Services, Inc., which initially rendered tax and accounting services. The business later expanded to include mortgage services, insurance, and financial services. Carol has also owned and operated other businesses. Nail Plus Salon and Boutique opened in December 1992 through February 1995. And Jasmine's, a gift and women's accessory store, opened in May in 1999 at River Park House Condominiums and is currently a home-based business. I'm sorry. Carol has appeared in several issues of Black Enterprise magazine under the Money Wise section, offering tax tips to readership. She has been involved in such organizations as the National Association of Black Accountants, the National Black MBA Organization, the National Negro Business and Professional Women's Club, Women's Entrepreneur Network, Inc., Philadelphia Congress of the National Congress of Black Women, National Coalition of 100 Black Women, Pennsylvania, Baltimore, and Virginia chapters, and Zion Baptist Church Wealth and Wellness Ministry. Carol has dedicated to helping individuals and small businesses achieve their financial goals through tax and finance planning. Will you please welcome Ms. Robinson? Thank you.
Good evening, everyone. Thank you so much, Erica. And I was so happy to hear Monica give her presentation, and I think we all can benefit from what she had to share with us this evening. So this evening, I am going to share with you some additional information. And if you give me a moment, I will be able to pull that information up momentarily. Okay, hopefully you can see what I have here. We're going to start with talking about Pennsylvania inheritance tax, and we'll conclude with exploring your life insurance options. One of the things I like to say about the Pennsylvania inheritance tax is that it can be a very complex issue and is personal to each individual, which is why we work with attorneys like Monica to navigate the process with the individual. So let's jump in and say, what is the Pennsylvania inheritance tax? Well, the Pennsylvania inheritance tax is a transfer tax on real and personal property assets of a decedent paid to a beneficiary at the time of death. Who should file a Pennsylvania inheritance tax return? The decedent's personal representative should file this return. And if the will does not designate anyone, the register of wills will appoint someone to file this tax return. or the trustee of an estate would also file the return. When must a PA inheritance tax return be filed, and where should it be filed? It should be filed within 9 months after the date of death of the decedent. If it's filed 1 day past the 9 months, the filing of that return can be subject to penalties and interest of the amount of tax due. So it's very important to get that in a timely fashion. Also, if you cannot file it within the 9 months, there is an extension that can be requested by the PA Department of Revenue, and they would allow you a 6-month extension. Now, that can be placed in writing, and it could be faxed or email or mail to them, but it's important to do it before the 9 months has ended. The Register of Wills in Philadelphia County can accept returns on behalf of the PA Department of Revenue. Also, other counties like Montgomery County, Delaware County, or Bucks County, for example, have Register of Wills offices. Now, for Philadelphia County, which I will mainly be talking about, you can mail the returns and they're sent to the Register of Wills in City Hall, room 180. You can also file the return in person to the Inheritance Tax Department in City Hall, room 177. What forms should I file? Well, if the decedent was a resident, you file Form Rev 1500, or a non-resident decedent would have filed Form Rev 1737. Forms and schedules can be found at revenue.pa.gov. Also, there is a complete guide that can be found at phillyvip.org that can help explain in more detail for those that want to attempt to file the return without the assistance of a financial person or an attorney. You can do so by following this guide. Who is taxed? What is taxed? Well, cash in the banks, and of course, personal property. Also, securities, things like mutual funds, stocks, bonds, etc. Real estate, and any jointly owned property. Revocable trusts, some retirement accounts, and closely held corporations, partnerships, or sole proprietors. What is not included on the PA inheritance tax return? Life insurance proceeds and some retirement accounts under 59.5. And for example, that would be an IRA if the decedent had passed away prior to becoming 59.5. And because of the 10% penalty that would be assessed on an IRA if you withdraw it prior to 59.5, this retirement account would be not included on the PA inheritance tax return. What can I deduct on a PA inheritance tax return? Well, of course, funeral expenses, and that's inclusive of cremation expenses, the hearse, the transportation of the body to the funeral home, flowers, and all of the things that a funeral director may list on a bill to you would be deductible. Attorney fees, personal representative fees, and accountant fees are also deductible, as well as debts such as mortgages, car loans, real estate taxes, medical bills, etc. There is a family exemption of $3,500 for the spouse and any child living in the same household. And that's important that they're living in the same household. Now, what are the tax rates for Pennsylvania inheritance tax? Well, it's 0% for a surviving spouse, 4.5% for a direct descendant, which could be your grandparents, mother, father, or child, 12% for siblings like brother, sister, stepbrother, stepsister, 15% for other heirs and non-heirs like nieces, nephews, cousins, and friends if they are left in the as a beneficiary. Property owned jointly by spouses is exempt, and there is a 5% discount if a return is filed within 3 months after the deceased death. As of January 1st, 2020, surviving children under 21 will now be taxed at a 0% tax rate. Now, what are the strategies that can minimize Pennsylvania inheritance tax? Well, one of the things you can do is set up joint accounts with your heirs. For instance, a bank account, because only 50% then would be subject to the tax once it passes at death. Or I should say at death, right? Purchase real estate property outside of Pennsylvania can be one of the strategies to be looked at. And you can consider investing some assets in life insurance, since death proceeds from life insurance are exempt from PA inheritance tax. That's going to bring me to talking about life insurance. And is life insurance a smart investment? Well, let's see. What is life insurance? Life insurance can leave a cash benefit to your selected loved ones, your beneficiaries. It can also give you living benefits. What are the types of life insurance? Well, there's term, there's whole life, there's universal life, and there's burial insurance, or final expense insurance, as it's called. What are the benefits of life insurance? Well, first of all, life insurance can build cash value, can have living benefits, which we'll talk about a little later. It pays out tax-free benefit to your beneficiaries. Again, it pays out tax-free benefits to your beneficiaries. It can last your entire life, and it can last for a selected period. It can also have riders, and that's what living benefits are. Riders that would allow for long-term care, terminal illness, critical illness, or chronic illness, meaning that you can tap the benefits of your life insurance without having, of course, died and passing on the death benefit to your beneficiaries. But keep in mind when this happens that you will be reducing the face value or the death benefit if you use a percentage of the face amount of that insurance for any of these types of illnesses. How much life insurance do you need? Assess your family needs when you are no longer here, and then determine what your long-term retirement goals are. Also determine your earnings and multiply that by 7 to 10 times your annual income. And that's done because you want to make sure that you leave your beneficiaries living in the way that they would if you were still here. And let's talk about the difference between whole life and term insurance. Well, term insurance will give you a guaranteed death benefit. It definitely has low premiums, and it has the ability to lock in premiums to a certain age. Also, it gives you coverage for a specific time, and that's normally 30 years. And it can be converted to permanent or what we call whole life insurance. And taking a look at whole life insurance, you have a guaranteed death benefit, just like term life. But the difference is it has a lifelong coverage, meaning it's there until you pass away. As far as the premiums are concerned, they stay the same. It builds cash value, again, locks in premiums for life. And it also pays dividends, which term life insurance does not. I do want to mention here that term life insurance can have a rider put on it where it would have your premiums returned to you after a period of time. So it's a return of premium feature that can be added to the term life insurance policy. However, I would say that that would increase the cost or the premiums of that life insurance. Now, what is universal life insurance? Well, universal life insurance is whole life, permanent life insurance. It has flexible premiums and it earns cash value based on money market rates and can allow for other flexible investment options to build cash value. The good thing about universal life, and I did an illustration for someone recently, where the term policy, because of the underwriting, and the underwriting can determine the amount of premium that you would pay. This universal life winded up being a better option because the universal life, as I indicated here, has flexible premiums, which means that you can start with a low premium, and as long as the investment portion of the policy is keeping up with the cost of the life insurance, as far as the life insurance company is concerned, then your premiums can be flexible. They can start out lower and then maybe be adjusted later on if they need to be adjusted higher. It's kept in force with a minimal premium paid. And as long as it doesn't go into a lapse stage, and of course the insurance company would notify you if that were to happen. But it's a flexible policy that can help those that may have cash flow problems with, during their period of time. So universal life is something to be looked at. What is burial insurance and final expense insurance? Well, burial insurance is a whole life policy that does not expire. It's an insurance that can pay for your final expenses, and the coverage amounts are normally between $2,000 and $50,000. It also accrues cash value. What are the age qualifications for the burial insurance? Normally, it's offered to people between ages 50 to 80. What are the types of final expense policies? Well, and that's the burial insurance. So there are types. There's a simplified issue policy that's limited to those without health risk, because there's underwriting to determine whether or not the person would qualify for this policy. There is medical history that's required, and you can be denied for pre-existing condition. On the other hand, there is a guarantee issue policy, which a lot of advertisement has been done. I know you've seen advertisements on Colonial Penn. These are policies that are more expensive once they take the application. And I know sometimes it's advertised that it's pennies on a dollar, but you have to be careful because once they take the information, it always winds up being more. Almost anyone can qualify for this type of policy because it is a final expense. And it has a 2-year waiting period before the benefits would kick in. And I'm going to see if we can talk a little bit about an illustration that I have put here to give you an example of a term policy with one of the companies that I'm contracted with and licensed with, Surety Life Insurance. This example is of a female, 55 years old, standard non-tobacco female with a death benefit of $25,000. It has a 10-year level premium. And what that is that the premium amount of $1,420 or the annual amount of $170 stays level for 10 years. So this particular person took the policy out at 55. And at 64, it ends, or I should say 65, the premium increases. And this is what happens with term insurance. Now, this same illustration could show 30 years. So if the person was 55 and it wanted to pay the same premium for 30 years, then it would take that premium amount being the same until that person turned 85. However, as you go down the age band, in this particular case, because it's only 10 years, you can see how the premium increases. And it's going to be at a time when the person is retired probably and on a fixed income. So it jumps from $170 a year up to, let's say, when they're 78, $2,039 a year. And that's when it's going to be very difficult to jump out of this policy into another policy, because the underwriting is going to be very difficult at that point, because you have health, most people have health issues, and then that means that the premium will definitely be too high for that particular person. The next illustration is going to be on whole life. The whole life illustration, same death benefit amount, face amount of the insurance, same age, same standard non-tobacco. Premium jumped up from $14 to $69.73 monthly, or an annual premium of $837. Well, when you look at this, the $837, and I only did this down to age 90, but it's for their lifetime. In addition to that, it builds cash value. Starting with the second year, you start to see how the cash value goes up. You can take policy loans out of the cash value as long as the death benefit remains the same. But as you can see, the death benefit in this column starts to go up. So you can take out money which would be non-taxable as long as it does not exceed the premium amounts that you have paid in. So this gives you an idea of the two types. I don't have the illustration for the universal life. I didn't have an opportunity to do that, but here, the term life insurance and the whole life insurance, you have to consider if you want to put the money out upfront, and the younger you are, of course, the lower the premium will be for life. So that's a decision that you would want to think carefully about and try to fit into your financial plan and your budget, so that when you're going down your age band later on in life, you have prepared yourself for something that you will be able to afford. And that concludes my presentation. Are there any questions?
Yes, we have a couple of questions. Give me 1 second. Okay. I'm sorry. We put them in 2 different places. Okay, so the first question is, if an account mutual fund bank account lists a beneficiary, is that taxed?
Under the inheritance tax, that's what they're speaking of.
It doesn't specify. It just says if an account mutual funds bank accounts or bank accounts list about beneficiary, is that taxed?
Yes, that's taxable.
Okay. What happens if nothing is filed?
Well, that's one thing I meant to mention. There is a penalty assessed, as well as interest on tax returns, inheritance tax returns that are not filed. And it would not exceed 25% of the tax due, or $1,000 is the maximum. However, there is a place where you can go under the PA Revenue Department that would allow you to go on and calculate what that interest and penalty would be based on the date that it should have been filed and the date you're actually filing. So it's revenue-pa-mypath.pa.gov.
Okay.
But
So-
at some point, I'm sure that the Department of Revenue, PA Department of Revenue, will send out some information or a notice about non-filing of the Pennsylvania inheritance tax return.
All right. Your next question is, should single childless people invest in life insurance?
Okay, that's a good question. And it really depends on your personal situation. Single childless people can look at that in several ways. Not sure if the goal is to include a partner or have children later on, or maybe consider adopting children or whatever. But you may want to consider looking at life insurance as part of your financial plan so that it's in place at a reasonable premium amount for what may happen later on. Yes, I do believe that, because again, you can invest in a whole life policy that builds cash value, and you never know, you may lose a job or whatever, you may need to tap into some funds, and your life insurance is there, because whole life has an investment side to it, as well as the death benefit.
Okay, I have two more questions for you. Is there a standard age of expiration for term life insurance policies? This is a two-part question. Is there a standard age of expiration for term life policies? And I'll give you the second part. Let me answer that.
Okay, and the illustration that you can take the policy, you can have a policy, say it would go to 90 or 95. The problem is you would have to look at what you could afford to pay, because the 30 years I had mentioned, a level term is what it's called, could let your premium amount stay the same for that period. But after that, it can increase significantly to the point where you would no longer be able to afford the insurance, and all of that money would have been paid in with no return unless you had a return of premium on the particular policy. So we could cover you, up until 90 and 95. It's just that it's so expensive at that point. Generally, what happens is the 30-year ends at about 85, meaning the premium amount staying the same. So after that, it's like, okay, I can't afford it, so I no longer have insurance.
Okay. All right, so the other part of that, I'm sorry, because I should have read the whole thing. It said, if yes, what companies can you recommend that would insure an individual over 80?
That would insure a individual
over 80, over the age of 80.
Okay. Those are normally your final expense policies. And as I said, you have some guaranteed issue and you have some simplified issue. However, there are some whole life policies with a couple of the companies that I am contracted with, and Assurity being the one that I showed you in the illustration. I just think that the premium based on the underwriting, because they table you, and I get a little complicated, or I should say complex with explaining this, but it depends on how the insurance company feels your risk factor is. So for instance, if you have health issues, they may decide that you're not a standard risk, but a much higher risk. So that premium is going to go up. For someone that's 80 years old, I would think that unless they are needing to care for someone after they have passed on, they would want to look at maybe a final expense, because it's not going to be as expensive, even though the I would say the guaranteed issue could be expensive, but not as expensive as a fully underwritten policy. So there are some Colonial Penn is out there. As you can see, the advertisements, you would have to call and answer the question to see, you know, what they would come up with. That's another company to look at.
Okay, next question is, are companies willing to convert term life into whole during advanced age?
Are companies willing to turn a term life policy into a whole life policy?
Yes, during advanced age. Are they willing to convert term into whole during advanced age?
That normally happens, and I get a lot of notices for that, particularly for the one company that I like, because they have flexible underwriting guidelines. By the time you're 64, they will be sending out letters suggesting that you would be able, or you're eligible to convert your term policy into a whole life policy. But keep in mind, at that age, the premiums become very expensive. And it is, again, determined on the underwriting and your particular health situation.
Okay. All right, one more. Are there paid up life insurance policies?
Yes, you can have waiver of, and I didn't mention this, but I'm going to mention it now, waiver of premium if you're disabled in an insurance policy, which is also could be a, you could get a rider for that. And you can have whole life policy that have built up enough cash value where you have a paid up policy. Yes, the answer to that is yes.
All righty. That is the end of our questions that I see. I don't see any more. Does anyone have any more questions before we end? Okay, so right now we will be hearing from Michelle Smith, and we thank you so much for your presentation, Ms. Robinson. Thank you.
Okay, thank you.
Okay, great. Thank you, Sister Erica, for thank you, Sister Carol, and thank you, Monica, for the excellent presentations. They were very timely and relevant. And now we are pleased to have Ms. Cheryl Gaston, Esquire, who is a member of the National Coalition of 100 Black Women, Pennsylvania chapter, and she will provide a personal testimony. She will share her experience on how she handled her mother's estate. Welcome, Cheryl.
Thank you. And I'm sorry, I am on my iPad here because, of course, my computer doesn't want to boot up like it should. But I wanted to just share a little, and I would have put my NCVW background on and the whole bit. But I'm going to talk about what I call the gift. My mother died on June the 28th of 2021. She got sick around this time, around Mother's Day, and she went really fast. But one of the things that she had done, and which I didn't know about, was my mother had a will. She had a power of attorney, and I'm the executrix for her estate. I'm the oldest. There's my brother. He's, younger, so that's the only reason why she did it that way. But at some point years ago, she asked me to meet her at a bank after my grandmother died, and she put my name on her accounts, and I didn't know what that was all about. But, when she was sick at different times, I was able to help her with those things. When she passed away, my aunt gave me this folder. And in that folder was the contract that she had made with a funeral director. And she had made all these arrangements for her passing here. She had picked out her own casket. She had included in this folder different dates and things that were important to her, poems, little sayings, things that we did use as part of her obituary, or what I call life story, and her, just some of the things that we did around the time of her passing and for her funeral. She made those arrangements back in 2009. And because there was an escrow account that secured the amount of the funeral expenses, we basically had a 20, I'm sorry, this thing is moving around, excuse me. We basically had a 2021 funeral at 2009 prices, which I don't think the funeral director was that happy about, it was, as I say, the gift. I was so upset at the time. You are making serious financial decisions. You're emotionally just battered here. And this took most of that out of it. Besides coming up with some of the things for the program and some of the ways that we wanted to do things, all of the big things were taken care of. So we called the funeral director. He came and he took her. They did everything. There was a limo that was included with it. There was, all these different things that I wouldn't necessarily have thought about at the time, but which my mother thought about. And in the end, it was, as I say, a gift, because I was able to do the things that she wanted done as part of her homegoing with confidence, because I was just following her direction. I didn't have to guess or make executive decisions, if you will. And I just, she didn't want a lot of flowers. She didn't want a whole lot of, my mother was not, she didn't want a whole lot of fancies, frilly kind of things, but she wanted something that reflected the kind and caring and smart and wonderful woman that she was. And one of her sayings used to be, my mother was a school teacher, and one of the things she would say when you did something really well was, you get an A on your paper. And with respect to my mother's homegoing services, I just wanted her to be in heaven saying, you get an A on your paper. And everything went really well. Even the repast, there were people who called me to say, your mother would have enjoyed this party had she been there. She would have liked what was done. And so I plan to do that for my own child. I think that it was, again, a great gift, and it made a time that was really hard that much easier. because again, I was honoring my mother's wishes. And I didn't have to worry about anything because she had made all the arrangements that were important and that she wanted to have reflected. And so I wanted to just share that, that we don't get to do, we don't get to decide when, okay? We don't get to decide when, but as I often say, none of us are getting out of this one alive. And if we can make things easier for those, our loved ones, then I think it's incumbent upon us to do that, and that they will be thankful in the end for our foresight and for the gift, as I say, of that we can give to them at a time like this. So thank you so much. And again, I just wanted to be able to give that little bit of something to carry on as part of this series where we can do what we need to for that day that we all have to come to. Thank you.
Wow, thank you so much, Cheryl. I'm in tears myself. Beautiful, beautiful tribute to your mother. It's wonderful. Thank you
Amen.
so much. Thank you so much, Cheryl. Okay, well, that concludes, everyone, our program for this evening. I want to thank again Ms. Monica Kitts, Esquire, Sister Carol Robinson, and Sister Cheryl Gaston for that beautiful tribute and testimonial to your mother. Thank you so much. Everyone, please, before you conclude or you leave the seminar, please complete the post-evaluation survey. The link will be shown at the conclusion of the webinar. Leverage the information learned today. There was a wealth of information, so much information. I know you didn't take everything down, but you will receive a summary of both presentations as well as a estate planning toolkit, compliments of Senator Vincent Hughes in your thank you email that will be sent out to you tomorrow. So please definitely share the information once you receive it. Share with your network. Don't sit on it. Definitely share the information. Also would like to remind you of our part 2 of our program, which will be next Tuesday, May 17th at 6:30, where we will have the Honorable Tracy Gordon of the Register of Wills, as well as Mr. James Leonard, Commissioner of the Philadelphia Department of Records, who will discuss the Tangled Title Crisis and the Probate Deferment Initiative. So if you have not registered, please do so. And I promise that will be an excellent program as well. And please also follow us on our social media platforms for more programs that we will be bringing forth to you in the future. Thank you so much, everyone, and enjoy the rest of your evening. Thank you.
Thank you, Cheryl. Thank you.
Good night.
Good night, everyone.
Everyone have a good night. Thank you.
Thank you.